On going through the entire materials, including the oral and documentary evidence laid in by both the parties and the judgment and decree of the trial judge, we are unable to accept the only reasoning of the High Court in non suiting the plaintiff. It is true that when the final bill was submitted, the plaintiff had accepted the amount as mentioned in the final bill but under protest. It is also the specific claim of the plaintiff that on the direction of the department it had performed additional work and hence entitled for additional amount or damages as per the terms of agreement. Merely because the plaintiff had accepted the final bill, it cannot be deprived of its right to claim damages if it had incurred additional amount and able to prove the same by acceptable materials. Before going into the factual matrix on this aspect, it is useful to refer the decisions of this court relied on by Mr. Altaf Ahmed. In the case of Chairman and MD NTPC Limited versus Reshmi Construction Builders and Contractors 2 SSC 663, which relates to termination of a contract. One of the questions that arose for consideration was whether after the contract comes to an end by completion of the contract work and acceptance of the final bill in full and final satisfaction, and after issuance a no due certificate by the contractor, can any party to the contract raise any dispute for reference to arbitration. While answering the said issue, this court held even when rights and obligations of the parties are worked out, the contract does not come to an end inter alia for the purpose of determination of the disputes arising thereunder, and thus the arbitration agreement can be invoked. Although it may not be strictly in place, but we cannot shoot our eyes to the ground reality that in a case where a contractor has made huge investment, he cannot afford not to take from the employer the amount under the bills for various reasons, which may conclude discharge of this liability towards the bank's financial institutions and other persons. In such a situation, the public sector undertakings would have an upper hand. They would not ordinarily release the money unless a no demand certificate is signed. Each case, therefore, is required to be considered on its own facts.